Welcome back to the channel and buckle up, because this case dives straight into one of the most emotionally charged and legally complicated situations we see in family court: a missing father, a confused toddler, and a mother trying to rebuild stability while the court decides what comes next. From the very first question, "State your name for the record," you might think this is a routine paternity hearing, but it becomes clear very quickly that nothing about this situation is routine. We have a father, Mr. Bay, who hasn't seen his child since she was 2 months old, and a mother who has carried every responsibility, every medical appointment, every decision, entirely alone.
State your name for the record, ma'am.
Devin Madeira.
And Miss Madeira, who is your child?
Stella Madeira.
And how old is your child?
Almost 2.5.
Okay. And who's the father?
Ladamian Baity.
Can anyone else be the father of Stella?
No.
Have you held out to other people that Mr. Baity is the father of Stella?
Yes.
And you're requesting this court for Mr. Baity to be adjudicated the father of Stella, isn't that right?
Correct.
Yeah.
Were you married to anybody else at the time Stella was conceived and or born?
No, ma'am.
Miss Madeira, what is the child's last name?
Madeira.
And do you want it to stay Madeira?
Yes.
Okay. Now, ma'am, when you're making important decisions like medical and dental decisions for the child, do you discuss this with Mr. Baity?
No.
Has
This
he ever
moment
been
right
helped?
here sets the tone for everything that follows. When a parent says the other parent has never helped with medical or dental decisions, it's not just an emotional statement, it's a legal red flag. Courts look closely at patterns of parental involvement, and medical decisions are among the biggest indicators of responsibility. Not being present for checkups, vaccinations, dental care, emergencies, these are all major markers of a parent's reliability. So when she testifies that she's made every medical decision alone, it signals to the judge that awarding her sole managing conservatorship may be the safest choice. And notice the judge doesn't challenge her here, because the consistency of her answers and the father's complete absence speak volumes.
Has he ever been helpful in making these types of decisions for the child with you in the past?
No.
Do you make all the medical and dental decisions for the child?
Yes.
Are you asking that the conservatorship be sole managing conservatorship?
Yes.
And you understand that that means that you're going to make all the decisions for the child?
Yes, sir.
Do you want to make these important decisions with the other parent?
No.
When you've taken the child to the doctor or the dentist, has he accompanied you or offered to drive?
No.
When was the last time Mr. Baity has seen the child?
October of 2023.
Has Mr. Baity visited with a child at all since October of 2023?
No.
Has he had any type of face conference online since October of 2023?
No.
Do you believe that Stella knows Dad if she sees him today?
Absolutely not.
This is one of the most emotionally heavy statements in the entire hearing. Absolutely not, she would not know her dad. Think about that. A child nearing 2.5 years old has formed her personality, her safe attachments, her understanding of the world, all without this man ever being part of it. And in family court, this matters deeply. Judges prioritize the child's emotional well-being, especially when introducing or reintroducing a parent after a long absence. This isn't just about reconnecting, it's about preventing trauma. For a toddler who doesn't recognize someone, sudden, unsupervised visits can feel like being left with a stranger. That's why the mother requests a step-up visitation plan, and you'll see the court take this extremely seriously.
Are you asking that some type of step-up visitation schedule be set so child and dad can get to know each other?
Yes.
Now, on phase one, where the visitation is from 1 to 5 p.m., the first, third, fifth Saturday of each month, are you asking that the periods of possession be 15 periods of possession?
Yes.
Okay. And are you asking that you be the supervisor, you supervise these visitations?
Yes.
Okay.
Can you flesh that out a little more? Because 15 is a lot. It's a lot to keep track of. And
Okay.
it's just a lot. I'm not sure why you're asking for that, but you might have a valid reason.
Why do you want 15 periods of possession, ma'am?
Knowing with how Stella is around new people and like other family members that she sees like on a regular basis, with how long it's like it took her to open up, if she was like just meeting them, as she's like been older, it took quite a bit, and she doesn't know him, she wouldn't be able to put him out of a crowd. So I believe that it would take at least that many, if not possibly even more, for her to be comfortable and stuff like that around him.
Her
Okay.
explanation here is incredibly important. She's not being dramatic or punitive. She's describing a behavioral pattern the court must consider: a child who takes a long time to warm up to people, even though she sees regularly. In family law, a step-up visitation plan exists for exactly this reason: to ensure a child's emotional safety during reunification. And the mother's real-life examples, coworkers she's been around for over a year yet the child still hesitates with, paint a very clear picture. For a child this shy, introducing a father she hasn't seen since infancy isn't simple. It requires patience, structure, and supervision, not for punishment, but for the child's sense of security.
Okay.
Does she have any diagnoses?
No, ma'am.
Is she a shy little girl?
Whenever she's meeting people first, it getting her out of her shell definitely takes a lot.
How long does it usually take for her to be comfortable with people?
If she sees them on a regular basis, I would say probably I'm going off of like coworkers that she sees on a regular basis with me, and I've been working where I am for a year and a half, and she still is shy with them. So it's a bit.
The judge is clearly trying to understand the child's temperament here, and this is crucial. Courts don't just look at parental rights, they look at the child's psychological readiness. A shy child isn't automatically a special needs child, but a slow-to-warm temperament means transitions must be handled gently. Her saying the child is still shy around people she sees weekly supports the argument for gradual exposure. Judges want to avoid sudden, overwhelming situations that could set a child back emotionally. This is a subtle moment, but a powerful one because it reinforces the mother's stability and understanding of her daughter's needs.
So you believe it's going to take 15 periods of possession before she is comfortable with that?
Yes.
You think maybe we need to increase the amount of time she sees him to speed that up and make her more comfortable?
I mean, we can. I don't know how that would work. Well, we can decrease it and I can see how that goes. Last time she saw him, she was 2 months old.
I
3 months
understand
old.
that when you get like a new babysitter, they don't usually visit 15 times before you leave them, or school, when you start school, like that's almost a whole month of school. And it's just very hard to keep track of too, like logistically.
And we can decrease it.
Yeah.
How much-
This is a strategic pivot. When the judge questions the logistical challenge of 15 visits, the mother shows flexibility, and that's something judges appreciate. It demonstrates reasonableness rather than rigid demands. By agreeing to reduce the number of supervised visits from 15 to 10, she signals that she's willing to compromise while still prioritizing her child's emotional safety. This also helps the court see her as a cooperative parent, which strengthens her request for sole managing conservatorship. In family court, cooperation is currency, and right here, she spends it wisely.
How much?
Mr. Damation?
Thank you, Judge. If you're going to decrease it, ma'am, what would you decrease it to?
10?
Okay.
I'm sorry, what was her answer?
Can
10.
you repeat that?
10, okay.
And where did you want to supervise these visits with Dad? Did you have a place in mind, ma'am?
Chuck E. Cheese in Webster.
Okay. And at Chuck E. Cheese, it's at 1541 West Bay Area Boulevard, Webster, Texas, 77598.
Correct.
Okay. Now on phase 2, it's the same 1 to 5 p.m., first, third, fifth Saturday of each month. But these visits are going to be unsupervised. How many periods of possession would you say did you want Dad to have in this phase 2? A reasonable period of possession.
Originally figured 15, but we can do 10 as well for that.
Okay. Moving along to phase 3. This is the daylight hours with Dad from 8 to 5 p.m., first, third, and fifth Saturday of each month. How many reasonable periods of possession would you require Dad to do on phase 3, ma'am?
We could do 10 for that as well.
Okay. Phase 4 is overnights with Dad, starting 6 p.m. on the first, third, and fifth Saturday of each month and ending 6 p.m. on the following Sunday. How many reasonable periods of possession would you require Dad to do on this phase, ma'am?
I'd say at least that one I would feel like would be more for like at least 12, 15 with those.
Which is it, 12 or 15?
I'll do 15.
And you understand that after phase 4, it'll go into the stand of possession order, isn't that right?
Correct.
And you're in agreement with that?
Yes.
Okay. Let's jump to health and dental. You have health and dental for the child, isn't that right, ma'am?
I will be getting it. She has access to it, and I will be putting her on.
Okay. Is the child on your dental through your work right now?
Yes.
Okay. And how much are you paying just for the child for the dental per month?
Written down. Uh, 1566.
Is that per month?
Yes.
Now we shift into the financial responsibilities, and here's where things become crystal clear. The mother is already paying for dental insurance and preparing to add medical insurance. Courts heavily favor the parent who has consistently provided essential care, especially when the other parent has not contributed anything. These numbers, $15.66 for dental and $355 for medical, may seem routine, but in legal terms, they establish a paper trail of responsibility. Every dollar she's paid strengthens her position. Every dollar he hasn't paid becomes part of the legal narrative the judge must consider.
Okay. And you actually had the child on dental for the month of September of this year, October of this year, and November of this year. Isn't that right?
Yes, sir.
And how much will it cost you to put the child on medical through your work?
$355 a month.
Okay. Now, what city does Dad live in?
Jasper.
Okay. And where does he work, to the best of your knowledge?
Currently living in Lake Charles for work.
Okay. Are you asking that the geographic be no restrictions?
Yes.
Okay. Now, Mr. Baity, he told you how much he makes, what his wages are, right?
Correct.
When was that? Time frame of when he spoke to her about this issue?
Of
On
his
the-
wages?
Because if it was, he hasn't seen the child since 2023, so if this was like 3 years ago, you told her that's vastly different than it was
No.
last.
It
Yeah,
was
I
What you
I
just
can- I
asked
can
for
flesh-
information does not give me that information.
I can flesh that out, Judge.
Okay, thank you.
Now, he recently, Mr. Baity told you how much he makes, right?
yes.
Okay. When did he tell you how much he makes?
I would say within the last month.
Did he explain why he didn't go in for DNA testing?
He said that no matter what he did, whether he tested or not, they were still going to put him on child support.
Did you respond to that?
I mean, I told him that was just ridiculous, and he doesn't care what I had to say.
Now, ma'am, you tried to call him before this hearing started today, isn't that right?
Correct.
And did you tell him that we had a hearing today?
Correct. His answer was, I forgot.
Okay. Did he? Okay. Now, which month did he tell you that how much he made?
October.
Okay. And what did he say? How much does he make?
He told me he made $3,000 a week.
Okay. And he told you this by phone?
Correct.
Okay. Why did he tell you over the phone how much he made?
I asked him if he would help, if he would send me money for diapers. And he told me that he didn't have the money for it. And then a few days later, he called me and was like, I've been lying to you. And I was like, about what? And he was like, how much I actually make. And I was like, okay, well, what do you actually make? And he was like, I make about $3,000 a week.
This is
Okay.
one of the biggest bombshells. The father admitted he lied about not having money for diapers, then later confessed he actually makes around $3,000 a week. Courts take financial dishonesty extremely seriously. Why? Because child support calculations depend on accurate income information. When a parent knowingly misleads the other parent, especially about finances, it undermines trust and raises questions about credibility. The judge now has to assess whether the $3,000 per week claim is real or another exaggeration. But the important part is this: the father hasn't contributed anything, despite allegedly making over $13,000 a month. That contrast is devastating for his case.
Okay.
What does he do?
Construction on the plants.
Now, does he have any other children outside this case?
No.
So if we calculate the child support based on what he told you, that would mean he makes $13,000 a month. Isn't that right?
Correct.
Judge, at this time, I offer State's Exhibit 3 based on.
Do you have any other evidence about what he earns, Mr. Dehumation?
No, other than Miss Madeira's personal knowledge testimony, no, I don't have anything current.
Have you even looked up what construction in the plants would typically earn per the federal websites or anything to see if this is in the ballpark?
I can check the United States labor statistics.
Has he worked at the plants before?
I do not believe so. I'm not exactly sure. Exactly.
Miss Madeira, to the best of your knowledge, has he worked in the plants in the past?
I don't believe so.
What type of jobs did he do in the past?
The OCBM or something like that. He was a truck driver for like a county maintenance. I believe is
So-
what his last one was.
So he drove a truck in the past.
This segment exposes major inconsistencies about the father's work history. He's worked as a truck driver, had county maintenance jobs, and may or may not have construction experience. To the court, this creates doubt not just about income, but about stability. When someone jumps between industries or has blurry employment records, judges struggle to calculate accurate child support. And because he didn't show up to court, he's not here to clarify any of it. That silence becomes its own testimony, and it speaks louder than words.
Truck in the past.
Correct.
And he did work at OCBM when he was served. Because that's where he was served. In May of 2025.
Miss Madeira, do you know if he's a construction manager?
I'm unsure.
Do you know what he's done in the past?
OCBM.
What does OCBM mean?
It's something for, I'm pretty sure it was county maintenance. Let me see. I can look it up. Oh,
That's a really high
building
salary.
materials. So delivered.
You sure you didn't hear him wrong? That it's like 3,000 a month? Or maybe
No, because I
3,000
even
biweekly?
I asked.
Do you know why they're paying him that much?
Unsure. I was actually shocked when I heard it as well. I don't know. He 100% could have been lying. That's what he told me.
Judge, I found a construction manager on the U.S. labor statistics. I can share my screen if you want, Judge.
It is totally up to you how you want to present your case. You just need to prove up your case in a compelling manner. And I don't believe I've admitted it into evidence yet. Do you know he's a construction manager?
Well, Ms. Madeira, do you know if
Does he
he's a
have any experience to be a construction manager, the skills?
I'm not sure. What he did before all of this, not a clue.
So you don't have any personal knowledge of what his title was prior to this job?
Mm-mm.
To the best of your knowledge, all you know that he drove a truck before, right?
Correct. Whenever Stella was conceived, he was unemployed, I believe. So I don't know, or whenever she was born, he was unemployed, so I don't know anything from before that.
Do you know if he's got a college degree?
Does not.
Has he told you that he's done a construction in the past?
I believe he has done construction in the past. I don't know what or where.
Okay. To the best of your knowledge, you're basically going off of what he told you.
Correct.
Now, what type of communication do you have with Mr. Baity?
At this time, we have no contact, except for to contact him earlier today. I had to do it on Snapchat. I don't have his phone number.
Okay. Are you asking for app close?
Yes.
So you can communicate with the other side?
Yes.
This reveals a deeper communication breakdown. When the only contact between parents is through Snapchat, that's a sign of unstable, unreliable communication. Family courts expect parents to communicate in predictable, traceable ways, especially when coordinating visitation and childcare. Her request for a co-parenting communication app isn't unusual. It's actually recommended in high conflict or low communication cases. Apps like these create a documented trail that courts can review later. It also shows she's trying to establish accountability, something the father has avoided by not providing a phone number, ignoring calls, and even forgetting the hearing.
Now, you're also asking for retroactive support, right?
Yes, sir.
Okay. And
I'm leaning towards a temporary order in this case and giving you all a chance to do some discovery.
Okay, Judge.
Why don't we wait on that issue?
Judge, we can reserve retroactive child support court costs for final orders then.
What does that mean?
It's going to be temporary. We'll be back for final orders.
And if he doesn't show up to that one as well, what happens then?
Temporary orders are crucial. Think of them as the legal training wheels of a case. They allow the court to create structure and safety while gathering more information. Here, the judge smartly orders temporary arrangements for visitation, child support, and communication because the father has provided almost no reliable information. This ensures the child is protected, the mother gets immediate support, and both sides have time to gather evidence before the final hearing. Temporary orders can dramatically shape the final outcome, so what happens from now until February 2026 is extremely important.
I could talk to you about that later.
Okay.
Judge Denton, we'd ask that you make appropriate rulings as to what the temporary orders are going to be.
I'm working on that.
Thank you, Judge.
I'm going to render, I'm ordering a temporary order in this case, so that discovery can be done, for testimony about wages. I'm ordering, and establishing the parent-child relationship between Mr. Baity and the child Stella based on the testimony presented. I'm leaving the child's last name Madeira. I'm appointing Ms. Madeira the sole managing conservator, and Mr. Baity the possessory conservator. At this time, I'm not ordering a residency restriction. For visitation, I'm going to order the stair-step visitation, the first, third, and fifth Saturday of the month, supervised by her or a competent adult at Chuck E. Cheese for 10 visits. Then 1 to 5 unsupervised for 10 visits. Then 8 to 5 unsupervised for 10 visits. And then 6 p.m. Saturday to 6 p.m. Sunday, we're going to do 10 visits. And then to the
This
standard
step-up
possession.
plan is textbook family court structure. It gradually increases the father's time and responsibility as he demonstrates reliability. Phase 1, supervised visits. Phase 2, unsupervised, limited time. Phase 3, full-day unsupervised visits. Phase 4, overnight visits. Then finally the standard possession order. This allows the court to monitor progress at each stage. If the father fails to show up, doesn't communicate, or doesn't contribute financially, the court can stop the progression. This protects the child while giving the father a fair chance to rebuild a relationship if he chooses to show up.
And then to the standard possession order. I doubt you'll get through all of this by the time you come back for final trial, so we can always reassess depending on what's happening. I'm finding that Ms. Madeira has insurance through her employment, as well as dental insurance through her employment. I'm ordering her to put the child on that insurance, and I'm ordering that Mr. Baity pay to Ms. Madeira cash medical support of $355 per month, beginning December 1st of 2025. I'm ordering that Mr. Baity pay to Ms. Madeira dental support of $15.66 per month, beginning December 1st of 2025. I'm basing child support on gross monthly resources of $6,500. One child before the court, and I believe no other children. And so that has net resources at $4,114.67 net. And so Mr. Baity is ordered to pay Ms. Madeira child support of $983 per month, beginning December 1st of 2025. And then I'm reserving the issues of back child support. I'm denying the non-disclosure request. I'm ordering app close, communication. Though, ma'am, since he's not here, I don't know that he'll know to download the app, so I don't know how effective this will be, but maybe it will work. And then I'm also reserving court costs, and I'm setting final trial for February 25th, 2026 at 9 a.m.
And that brings us to the end of this hearing, a case filled with emotional weight, unanswered questions, and a child at the center who deserves stability above all else. The judge's temporary orders lay out a clear path. Heavy checkmark: the father is legally recognized. Heavy checkmark: the mother retains sole managing conservatorship. Heavy checkmark: the father must pay medical, dental, and child support. Heavy checkmark: visitation will begin gradually, only if he participates. Heavy checkmark: a final trial is set for February 2026. This case highlights a powerful truth about family court: showing up matters. Providing documentation matters. Consistency matters. And when one parent handles all responsibilities alone, the court takes notice. What happens next will depend entirely on whether the father steps up or continues to remain absent. If you found this case as shocking and insightful as we did, make sure to hit that like button, drop your thoughts in the comments, share this video, and subscribe for more real courtroom breakdowns that pull back the curtain on how justice really works.
And we'll see what's happening then.
Can you repeat what date that was?
February 25th, 2026. And then the state's going to draft the order based on my ruling today, and they'll be circulating it to you through DocuSign to review and sign off on. And then you'll be free to go for the day, and then we'll see you back in February. Hopefully there'll be some more information then to make a more precise ruling on some of these issues.
Okay.
Do you have any questions, Mr. Damasian, about the ruling?
No, Judge. No, Judge. I wrote everything down. I'll write it up.
Okay, thank you. I'm going to stop the recording.